Number 47, the people of the state of New York versus Sergey Aleynikov. Thank you. Counsel?
Good afternoon, Your Honors, and may it please the Court, with the Court's permission, I would like to reserve 2 minutes for rebuttal.
You may, sir.
Sergey Aleynikov's conviction under the unlawful use statute must be reversed for 2 reasons. First, the digital transfer of computer source code does not make a tangible representation or reproduction of that intangible property. It makes an equally intangible copy, one that can only be seen with the aid of a computer. The source code Mr. Aleynikov copied was as intangible on the computers and flash drive that he owned.
Let me ask you this.
Yes.
If your client had put together a PowerPoint, and I know you can't really read code in this way, which is part of my problem with your argument, but let's say he put up a slide on the screen, and it's got some snippets of the code.
Yes.
Is that a tangible reproduction?
Absolutely not.
Why not?
Because tangible has a specific meaning in the law, and it always has.
You have to be able to touch it? So if he printed out that PowerPoint slide and handed it out, it's
Yes.
a tangible reproduction?
Yes, it would be. Yes, it would be. But a tangible reproduction means exactly what that term has always said, which is something that can be perceived by the senses. That's the big deal. That's why Agrawal said what it said.
Why isn't the court below correct that if it's taking up space on the hard drive, that is tangible within the meaning of this statute for this kind of secret material?
Because, Your Honor, that's as metaphysical a distinction as I could possibly imagine. The reality is, when the legislature in 1967...
Well, if it's taking up space, that means something else can't sit there. So it's tangible.
It doesn't mean that one can perceive it. It doesn't mean perceptible by the senses. That's what tangible means and always has meant.
Well,
that's what.
Well, slow down. Black's Law Dictionary has having physical form, number 1. Number 2, capable of being touched or possessed. And number 3, capable of being understood by the mind. Maybe not my mind, but there are minds who can understand source code. And it seems to me that it would fit within that third category. The other part is that the tangibility of source code, or in fact any intellectual property in its first conception, will not be there. It's only in the reproduction of a particular intellectual endeavor where it exists. For instance, an alphabet doesn't exist. It exists in my mind, but it does not tangibly exist until I reproduce what's in my mind and put it on a piece of paper. The same would apply to a piece of music, a poem, or a variety of other things. And source code I would consider to be that kind of endeavor.
Every single court to consider this issue, and I mean all the judges that sat on the Agrawal panel and the Aleynikov panel, and many judges on many other courts around the country, but those judges considered this very source code, and they recognized that it is as intangible on Mr. Aleynikov's computer as it was on Goldman's computer. You say it doesn't really have any form until it's reproduced. How can that be? In its native form, it's intangible property, and every court to consider the issue has said it. What does it mean? America Online, the Eastern District of Virginia. Computer data can be transmitted and stored in a variety of ways, but none of them renders the data capable of being touched. A bit on a computer disk is not palpable. Electrical impulses that carry computer data may be observable.
But if you copy it on a thumb drive.
Yes, you copy it on the thumb drive is tangible, but
the vessel is tangible, correct. It's, excuse me, it's like copying it onto a piece of paper.
No, it isn't.
The paper is the vessel, you move it around, right?
Respectfully, Your Honor.
Okay.
I have something printed out on a piece of paper.
Correct.
I can perceive this with my senses without any difficulty whatsoever. But I cannot perceive computer data on a computer without the aid of a computer. Why do you think tangible was in that statute in 1967? Because historically, that was a critical component of theft. that you could only take something tangible. This court in Thyroff tackled this issue, and it said, and there was no mystery in Thyroff. Thyroff made it very clear that to become tangible, intangible things like source code have to be attached to something tangible, right? That's the tangible basis. That's for conversion law. In the law, the tort of conversion, this court is free, and it's quite appropriate for this court to modify the common law to meet the felt necessities of the
The
time.
only way to reproduce it is in this way. When you have a
No.
source code, the only way to reproduce it is in this way, right?
No, that's not accurate.
And so we're talking about the reproduction being tangible.
That's what it has to be. The reproduction has to be intangible. That's what happened in Agrawal. Agrawal did exactly what Aleynikov...
You say there are other ways to reproduce it that fit under the statute. What would that be?
Print it out.
And what meaning would that have to someone?
Because you can touch it, you can see it, you can read it.
No, I get that part of it, but what meaning would it have? How would one use that source
Oh,
code?
I'm sorry, Your Honor, I didn't
Yeah,
take your meaning.
Yeah.
Because computer source code is human readable instructions.
Yes.
You print it out, it will tell you precisely what to do. When Mr. Agrawal was in his office
But
at
no,
Stock...
if you see it on your computer screen, it'll exactly in the same way tell you exactly what to do, won't it?
Well, first of all,
Be
no, that's
capable
not
of being
cool.
understood by a mind that is versed in computer source code.
Well, Your Honor, respectfully, if the phrase means capable of being understood by the mind, I would submit that it is entirely superfluous in the statute.
But the
What
point
would
is-
an intangible
But the
reproduction
point
look like?
is what is the purpose of being able to touch it? The purpose is being able to use it.
Well,
isn't it?
Your Honor, the purpose in the law of larceny as it has developed over the years, the purpose in a statute such as this is that historically only tangible reproductions, only tangible property could be stolen.
But
This
that's
is-
the whole point, is we're not talking about larceny. This statute was created to fill a loophole that larceny didn't cover.
Your
And
Honor,
so-
I respectfully completely disagree with that. This statute was passed in 1967. It was created after United States versus Baton made it clear that the National Stolen Property Act did not apply to intangible property. The idea was if someone could steal your photocopies by taking the then nascent technology of a Xerox copy machine and walk out the door with it and not have copied it, not have stolen it, that was a problem.
So
that's the gap that
If
was
the
this
source
was designed
code,
to fix.
if the source code was printed.
Yes.
You agree this is a problem?
100%.
All right.
That's what
So-
happened in
So hold on.
Agrawal.
So what if it's printed in 1-point font so that you and I can't read it with our naked eye, but we need a magnifying glass to read it?
I guess you could
Why
fathom
is the
a
magnifying glass
circumstance.
different from the computer?
A magnifying glass is different from a computer.
Why?
But Your Honor is positing a scenario in which something is written so small
That's right.
that it's not really perceptible by the senses. But I would tell you, if I hold it close enough to my face, I can do exactly what a magnifying glass can do. The
You would not be
problem
able to do
is-
that with 1-point font. You
I beg your
wouldn't.
pardon?
You wouldn't be able to do that with a 1-point font. You would not.
Your Honor, if the notion is that the legislature of New York meant nothing when it incorporated that word tangible into the statute, I agree with you. It means nothing because Mr. Aleynikov did something that should be punished, right? The DA knows that this is improper. The task force report could
Well, let me
not
ask you
make
this.
clearer.
Is it your argument that it's not a reproduction? Put aside tangible for one moment. You just say this is just not even a reproduction?
It's an intangible reproduction. It's the reproduction of bits and bytes on a computer. These are electrical impulses. I would respectfully submit that there isn't a conceivable chance.
But since you say it's a reproduction, you do say it's different from what he left at Goldman Sachs, correct?
It is different. It being what was transferred.
The source code, where we started, the original source code
Yes.
on Goldman's computers, however
Yes.
they retain it.
Okay.
Right?
What-
I asked you if you were taking the position that what your client did here would not be a reproduction of that source code, putting aside the word
Yeah,
tangible
it's a-
in
yes,
the
it's a-
statute.
Yes, it's a reproduction of the source code, 100%. And that's
So-
what he did. He made
So
a
he
copy of it.
reproduced it,
Yes, he did.
and he didn't reproduce it by merely bringing it up and viewing it on the screen, correct?
Never brought it up and viewed it on the screen. He reproduced
Well,
it
we
by
don't-
he reproduced it by digital transfer.
At some point, he brought it up on the screen. But
Actually,
I don't need that answer right now.
I understand.
But is it your position then that when he saves it and it now is displacing where something else would go? It's not a reproduction that at that point becomes tangible?
It is not tangible property ever. That's what America Online
If we
said.
disagree with you about the definition of tangible, then does the fact that it takes up space, physical space on something, that we can say it's located either in Germany at some point in time or in New Jersey at some point in time, do those things mean that then, it's
Your Honor,
tangible?
Your Honor, it doesn't take up space in any sense of that phrase.
Well, there's certainly evidence, there's testimony that it does.
Naveen Kumar testified, Your Honor, that it does not have physical form. Everyone knows what we're talking about. The judges of the Court of Appeals for the Second Circuit said the following: the computer source code that Sergey Aleynikov transferred was intangible when he took it, and it always remained intangible. Why do you think that the White Collar Crime Task Force has recommended these sweeping changes to the statute to the larceny law that would get rid of all of this? And earlier, Your Honor said this is not a larceny statute. It's not grand larceny. It is a larceny statute beyond peradventure. It's a larceny statute because it exists in Title J. It takes the definitions from Title J, and it is, for that reason, it's about stealing. What Justice Conviser said in his very thoughtful 72-page opinion on the subject was, you don't steal something without actually taking it away. This is this whole notion that, well, appropriate and deprive are somehow you don't have to have a deprivation when you have appropriation.
What about when you steal somebody's cable services?
Yes.
Is that a crime?
Is it a crime to steal
Yeah,
someone's?
Well, they have the use of their cable TV subscription or whatever, and you hack into it. And so you're now using it as well, okay, but so are they.
Yeah, that's right. Certainly it's a crime.
Okay, so
Certainly.
how's this different?
This is different because what Mr. Aleynikov did here is make a copy that in no way, shape, or form deprived Goldman Sachs of anything.
Well, in the same way as the cable user, okay, the cable user still had full access to their cable, okay, but now somebody else does too. And for Goldman, that may mean a loss of market share, it may mean a whole bunch of things. So how can you say that they haven't lost it?
Because you'd have to prove that what Mr. Aleynikov took in some way, shape, or form deprived Goldman Sachs of something.
Isn't that what Kumar's testimony really shows?
I don't believe so, Your Honor.
Well, it seemed to me to be the biggest difference between the proof that was offered was his testimony. I thought his testimony was kind of key. Would you agree with that?
I would. He agreed with every single concept that I proposed to him on cross-examination. I thought he was terrific.
Well, we'll see how the people feel about it.
Thank you,
Okay.
Mr. Marino.
Thank you very much.
Counsel?
Thank you, Your Honors. May it please the Court, Elizabeth Roper for the people.
Do me a favor and go to that point. Let's stay on that point, on Kumar's testimony.
Okay, of course. Naveen Kumar testified very clearly that when computer data is saved electronically to a hard drive, it physically exists on that hard drive and takes up space. He gave the helpful example or analogy of data that's saved to a compact disk.
And Mr. Kumar, of course, he worked for Goldman Sachs.
He did, and he was
And
one
he
of
developed a system, what is it called? OBD? Is it ODD?
OBB, the order book builder.
All right. And did he testify, as I recall, that there was elements of that were outside of the open source code and were proprietary to Goldman Sachs?
Absolutely. The
And he
testimony
had
was...
personally developed that particular type of source code.
That's absolutely true.
Okay, go ahead.
Under every common meaning of the word tangible, the reproduction of Goldman's code that the defendant created on the German server was tangible. It had physical presence, it took up space, it was capable of being possessed, and it was just as perceptible to touch as it would have been on a piece of paper. The unlawful use statute is incredibly clear, and it describes in clear terms precisely what the defendant in this case did. He surreptitiously electronically reproduced material, making a physical copy of it so that he could use it later for his own
Can you have an
benefit.
intangible reproduction of a source code?
I'm
Which
sorry.
is his position. Can you have an intangible reproduction of a source code?
In this context, it's hard to think what an intangible reproduction would be. I think in this statute, the word tangible emphasizes that in order for a defendant to be criminally liable, there needs to be a physical reproduction of the material.
What if you memorized it?
A defendant would not be liable for mere memorization.
That would be intangible.
That could be considered an intangible reproduction, absolutely. And that might give rise to civil liability for something like the violation of a confidentiality agreement. But the unlawful use statute clearly emphasizes that for criminal liability to attach, there needs to be a physical representation or reproduction made. And the statute goes further and specifically enumerates the ways in which a defendant can make it tangible reproduction: writing, drawing, photographing, or mechanically or electronically reproducing material. And so it explicitly describes exactly what the defendant in this case did. He created a physical copy of this data by electronically reproducing it. Our common sense tells us the same thing.
Well, isn't a physical copy if he had printed it out?
It also would have been a physical copy if he had printed it out. To Your Honor's earlier point, it might not have been as useful to him, but in either circumstance, it would have been physical by virtue of its manifestation on a physical medium, and that's what the statute requires.
So your argument is it's physical because it's in the hard drive, something that one can touch?
Yes, absolutely. It's connected to a physical medium, and that's what the statute contemplates. That's exactly the type of physical existence that the statute requires. This court's holding in Kent also supports the view that digital files can be tangibly reproduced and possessed. In that case, the court was considering whether a defendant knowingly possessed certain digital images. And in conducting that analysis, the court referred to the tangibility of the images as their permanent placement on the defendant's hard drive and his ability to access them later. And there's certainly nothing controversial about the notion that a defendant can possess digital files. That's the basis for prosecutions under several statutes. And so here, the tangibility of these files was their placement on the German server, the fact that they took up space on that server, and the fact that the defendant could and did go back and access them later. There's also no question that the defendant had the requisite intent in this case. He had the intent to exercise permanent control over the use of the code that he copied, and that's what the statute requires. The defendant took extensive steps to obfuscate what he had done. He copied thousands of proprietary files in the final hours of his last day of work at Goldman. He encrypted those files as he sent them out of the network. He backdated the program that he had run to copy those files, and he erased the history of commands that he had run on his computer. All conduct that was designed to make it unlikely that his copying would ever be discovered. And more importantly, we know that he did use the files. He uploaded them to Tez's servers after he began work there and presented them as his own work product. So there's no question that this defendant had the intent to appropriate the use of that material. He did use it. There's no...
Are you familiar with this court's case, People v. Kent, I think it is?
Yes, Your Honor.
Okay. For us to rule in your favor, would we be overruling Kent?
No, the ruling would be completely consistent with Kent.
How so?
Well, as the appellate division held, Kent supports the notion that digital files are tangible and can be possessed. In Kent, the question was whether the defendant knowingly possessed certain files that were present in his internet cache. And so there wasn't necessarily evidence that the defendant had deliberately downloaded and saved those files. There were other files where it was clear that the defendant had deliberately downloaded and saved them. The court noted, in holding that the cached files were not knowingly possessed, the court noted that there was precedent in some other jurisdictions where courts found knowing possession just based on the tangibility of the images. And it defined the tangibility of the images as their permanent placement on a defendant's hard drive and his ability to access them later. So the same definition of tangibility applies in this case. These files were permanently present on the German server, and the defendant could and did go back and access them later.
Counsel, your colleague made several references to the white-collar task force report and the conclusions that were drawn. Do you care to address that?
Yes, Your Honor. What this defendant did should be punishable as the Class B felony of grand larceny in the first degree. We're talking about the misappropriation of millions of dollars, hundreds of millions of dollars worth of materials. And the task force report advocated reforms that would enable us to prosecute it that way. The point wasn't that the unlawful use statute or other existing laws aren't applicable. The point of the task force report was that those laws aren't sufficient. that this should be punishable as a Class B felony.
Well, what about the argument that open source code is available worldwide and that the vast majority of information in the open source code was available to the public on the internet, and so to punish this one person for this thing seems to be like an enormous overreach, given the availability of most of this information?
Your Honor, there simply was no evidence that any of this material was open source material. Just to the contrary, Naveen Kumar and other programmers testified that they had personally developed.
The way I understood their testimony was that parts of the code, you're going to know this better than us, but parts of the code were open source and parts weren't, and that Kumar's testimony may have been helpful to you because it identified those areas of parts that were not open source code.
In fact, the words open source did not appear in the testimony at all.
Okay.
There was testimony that certain programs, including the programs developed by Mr. Kumar, had used what I think the witnesses called textbook principles that they had learned over the course of the years. But that doesn't mean that those materials were open source. That has a specific meaning, and there was simply no evidence that any of this material fit that definition. In fact, it was just to the contrary, and the jury found beyond a reasonable doubt that this was secret scientific material, which is defined as secret material that confers a competitive advantage on its owner. So not only was there no evidence of it being open source material, there was evidence affirmatively that it was not open source material.
Can we go on to appropriate and discuss any response you may have to your adversary's argument that in order to appropriate, you have to deprive of economic benefit?
Absolutely.
Deprive the person you're appropriating it from of economic benefit?
This statute simply does not require an intent to deprive or a deprivation at all. As the court is certainly aware, the intent to appropriate and the intent to deprive are separately defined mens reas under New York's larceny statutes. And the unlawful use statute refers exclusively to the intent to appropriate. And it's the intent to appropriate the use of the material, not the material itself. Both of those things underscore the fact that this statute doesn't contemplate any sort of deprivation. It's a statute that talks not about the taking of material, but the copying of it. And the legislative annual introducing this statute explicitly stated that it was intended to cover conduct that would not traditionally be subject to a larceny prosecution because there is no traditional taking. So there's no intent to deprive required here. But the fact is that the evidence did show that Goldman was deprived of something, their exclusive use and possession of this code. Exclusive possession is an important possessory right. That's what the Almeida case recognized. And it's particularly significant where the property at issue is secret intellectual property. Essentially, the entire value of this property rests in its exclusivity. And so while there was no requirement that we show the defendant intended to deprive Goldman of anything, the fact is he did deprive them of something incredibly significant. Your Honors, I see that my light is on, and so if there are no further questions, I would just conclude by saying that this is not an awkward or strained application of this statute at all. The defendant's conduct was exactly what the unlawful use statute was designed to prohibit, and we respectfully ask that the court affirm the appellate division's unanimous decision.
Thank you, counsel. Mr.
Thank you.
Marino?
Thank you very much, Your Honor. Judge Fahey, you asked the question, would you have to overrule Kent? 100%. Here's what Kent said. Federal courts have held that for digital images to constitute evidence of knowing possession of child pornography, such images must be connected to something tangible, e.g. the hard drive. The entire principle underlying Kent, and for that matter, underlying Fyroff, was exactly this. This is intangible property. The question was put, what would an intangible reproduction look like? And if the answer is, I can't think of one, that makes the word tangible superfluous in the unlawful use statute. So in Fyroff, this court well recognized and at great length went through the history of the civil law of conversion. And it explained, and it did this for this in this exact circumstance involving computer information. And it realized that there was no way the traditional tort of conversion would cover that. And the reason for that is plain. For time immemorial, conversion has entailed the use of tangible property. So the court says, and it's really quite interesting, this is what you're being asked to do. You're being asked to do what the court
Sure,
in
you
Thyroff
take
would
the
do.
property, you keep it, and you use it, but of course, with the source code, what he has done is make a copy of it.
Yes,
In fact, he didn't want anyone to know he made a copy of it.
Yes,
That's the whole point.
There's no doubt about
right?
that.
Unlike in tangible property, the owner knows the property is gone, a missing, as
That's
they
right.
say.
And in Thyroff, what happened was Nationwide decided that it was going to take Mr. Thyroid's computer property back. They decided that he was no longer going to work for them, so they were going to just take it back. And he sued them for conversion, and he won, right? He won. Why did he win? Because the court said, and I quote, "We believe the tort of conversion must keep pace with the contemporary realities of widespread computer use." That's not your province with a criminal statute. The Supreme Court of the United States said this last week in Marinello. We are very loath to expand the scope. Is what Mr. Aleynikov saying not plausible? Is it not plausible? Is what the three learned judges of the United States Court of Appeals for the Second Circuit said in Agrawal, that it was intangible property that always stayed tangible, even when it was on a hard drive? Is that implausible? Because under Galb, if it's not implausible, or if it's not implausible to believe when you say you appropriated something from me, you actually stole it, if that's not implausible, Mr. Aleynikov must win.
Thank you, Counsel.
Thank you very much.